pounding on my picture?
I pound on my desk all the time. There was a pile of papers. I remember that.
Okay, all right. And the reason I'm doing this is because when you went on the air and did all that, do you remember the video we just saw earlier in which you said, it's not just one, you have a bunch of parents doing that? Do you remember?
I told you I didn't say their name.
Good point. Where you said, it's not just one parent doing this, but a bunch of parents. Did you remember seeing the video?
Yes.
That was you in it, right?
Yes.
You chose to say that. Nobody made you say
Yes.
that, right?
This is far from over. Alex Jones, there's a number of things that he can do. First of all, he's going to appeal, according to his attorneys. And there are some significant issues on appeal. This is a very unusual trial. The court basically put him in default, and they went straight to damages. And that's very unusual, and that's a very draconian ruling by a court. That's a ruling that's the last choice a court will have. And a court of appeal is going to really scrutinize that. A judge is required to, if a litigant is not participating in discovery or is violating, the litigation standards, the judge, there's a number of things that a judge can do before actually putting him in default. And also with damages, they're going to look at damages. The damages award needs to be supported by the evidence. And now, although jurors, have a lot of room with what we call non-economic damages, which are damages for emotional distress, reputation to one's a profession in a defamation case, still a court of appeal is going to look at that. And so the appellate side is very rich here. And it's very possible this judgment could get discharged in bankruptcy. There are a few debts that are not dischargeable, but there's a high standard to meet those, prove in a bankruptcy court why a debt should not be discharged. So it's very possible that both the compensatory damages award and even the punitive damages award, depending on what it's based, could be discharged. And if that's the case, this judgment's wiped out. And on top of that, he continues his fundraising off of the trial with his base. He could start to build up his coffers. Bankruptcy either is not elected or the debts are not discharged. And now the plaintiffs want to collect. Well, that's a challenge in and of itself. Each state has certain assets that are not collectible, that they protect. And then you have to go and you have to find the money. And I can't tell you, in my own profession, how many judgments I've had that it's just trying to hunt for collection and be able to actually get, the clients any money. It's very difficult. And nowadays you can hide assets, through the different laws that the states have. It's very difficult to collect. And so Jones is not done here. A good example is O.J. Simpson. I mean, he had a $33 million judgment against him in the 90s, and he seems to have lived a pretty decent life. And from what I understand, they haven't collected any money from him. And even though he's kind of flaunting around. So it's very difficult to collect. The plaintiffs had two goals, in my opinion, here: justice and money. And they achieved the first goal through justice. This award, it makes a huge statement. They were validated, they were believed, and they were significantly awarded, and on a very, public level. So they have achieved justice. Now comes the money. And one option is to agree to accept a lesser sum. Which means, Jones will agree to pay a certain amount, and they'll agree to satisfy or discharge the judgment, and have it go away. And in many ways, this is the best result because, rather than trying to deal with an appeal, deal with the bankruptcy, trying to collect, the plaintiffs will definitely get money for sure. And the incentive for Jones is this judgment will be lifted off his head and he can go, live the rest of his life.